Well, the Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not. At the end of the day, Congress passed a body of law known as the Immigration and Nationality Act, which stripped Article III courts, that's the judicial branch, of jurisdiction over immigration cases. So Congress actually passed, it's called jurisdiction stripping legislation. It passed a number of laws that say that the Article III courts aren't even allowed to be involved in immigration cases. Many of you probably don't know this.
And starts viewing it as potential criminal conduct. That moment has now arrived. And at the center of it is Stephen Miller, the Deputy Chief of Staff to the President and widely regarded as the chief architect behind one of the most aggressive and legally controversial immigration enforcement agendas in modern American history. This escalation did not come from Congress. It did not come from media pressure. It did not come from partisan attacks. It came from the written opinion of Chief Judge James Boasberg of the United States District Court for the District of Columbia, a formal judicial finding now permanently embedded in the federal record. And what that opinion says is extraordinary. The clash began when Judge Boasberg blasted the Trump administration over deportations to a notorious prison in El Salvador. According to the court, the administration carried out removals even after. He issued a clear order to halt them, including directing that planes already in transit be turned around. They weren't. The aircraft landed. The removals proceeded. Now the judge is preparing a formal contempt investigation, one that could include sworn testimony under oath. Until this point, disputes between the administration and the courts over immigration enforcement had largely been handled under civil contempt procedures. Civil contempt is corrective. It is meant to coerce compliance. It results in fines, deadlines, procedural consequences, pressure designed to make the government follow the court's order moving forward. But Judge Boasberg has now crossed a line that federal judges rarely cross. He shifted the matter from civil contempt into the far more serious territory of criminal contempt. That distinction changes everything. Civil contempt asks, how do we make you comply? Criminal contempt asks, did you commit a crime by defying the court? In a written opinion, Judge Boasberg stated that there is probable cause to believe senior officials engaged in willful disregard of a binding judicial order. He did not describe confusion. He did not describe good faith disagreement. He described deliberate defiance, and he named names: Attorney General Pam Bondi, Secretary of State Marco Rubio, Deputy Chief of Staff Stephen Miller, and President Donald Trump. The opinion lays out, in painstaking detail, what the judge concluded was a pattern of acting in contradiction to a clear court directive, while simultaneously representing to the court and the public that the administration was complying. The court called those representations false, not mistaken, not misunderstood. False. That finding is what elevates this situation from political controversy to potential criminal exposure. To understand why this battle exploded, you have to look at the legal foundation beneath it, the Alien Enemies Act of 1798. This is a wartime statute, a relic of early American history, designed to allow the president to detain and remove nationals of enemy countries during times of declared war or invasion. It has been invoked during actual wars, most notoriously during World War II, when it contributed to the internment of Japanese Americans, one of the darkest chapters in U.S. constitutional history. The Trump administration argued that modern immigration flows and border conditions constituted an emergency severe enough to justify invoking this wartime authority. Civil rights groups immediately warned that this was a radical expansion of executive power, an attempt to apply a war statute outside of wartime conditions. Judge Boasberg reviewed the administration's use of the act and issued a binding order imposing strict procedural safeguards to protect Fifth Amendment due process rights. The order was not advisory. It was not negotiable. It was not optional. It was binding, and according to the court, it was ignored. On March 16, 2025, the judge concluded that the administration proceeded with detentions and removals without providing the procedural protections he had explicitly required. Individuals were detained, processed, removed, without the safeguards mandated by the court. Meanwhile, the administration maintained that it was in compliance. The judge concluded that it was not. The Fourth Circuit Court of Appeals later echoed these concerns, reinforcing findings that senior officials relied on what the court described as outright untruths while depriving individuals of constitutional protections. The fact that two separate federal courts, at different levels of the judiciary, reached similar conclusions significantly undercuts any argument that this is merely personal bias or judicial hostility. For Stephen Miller, this development is particularly dangerous. Miller has long been identified as the intellectual force behind many of the administration's most aggressive immigration measures, from family separation policies to expedited removals and expanded executive detention authority. For years, the political calculus appeared simple. Push the limits, accept civil lawsuits, absorb judicial criticism, and rely on political support to weather the storm. Civil fines, manageable judicial rebukes, survivable procedural setbacks, temporary. But criminal contempt is different. Criminal contempt is punitive. It addresses past conduct, and it carries the possibility of federal prosecution and imprisonment. That is the line that has now been crossed. However, a finding of probable cause does not automatically mean charges are imminent. It means the court believes sufficient evidence exists to justify prosecution. The next step typically falls to the Department of Justice, and here lies the complication. The Attorney General herself, Pam Bondi, is named in the contempt finding. That presents an obvious conflict of interest. It is difficult to imagine the Department of Justice objectively evaluating whether to prosecute its own leadership without the appointment of an independent counsel or special prosecutor. If such an appointment occurs, the matter would move outside the administration's direct control. If it does not occur, that refusal could spark an entirely new constitutional confrontation, reinforcing the perception that the executive branch views itself as insulated from judicial accountability. This is no longer just about immigration enforcement. It is about separation of powers. It is about whether federal court orders are binding on everyone, including the highest officials in government. Judge Boasberg's decision represents a judicial escalation unlike most seen in recent history. Rather than continuing ineffective civil enforcement efforts, he has signaled that the judiciary is prepared to deploy its most serious enforcement mechanism when defiance persists. For Miller, the implications are profound. For years he operated under the assumption that aggressive enforcement tactics, even if legally risky, would remain politically survivable. Now the legal terrain has shifted beneath him. A federal judge has formally documented that there is probable cause to believe criminal contempt occurred. That opinion will not disappear. It will follow each named official in every future legal battle. It will surface in congressional investigations. It will be cited in historical analyses of this presidency. Even if charges are never filed, the finding itself is permanent. The road from probable cause to prosecution is complicated. Political realities are enormous. Institutional resistance is real, but the legal marker has been placed. The question now is no longer whether the courts are willing to escalate. They have. The question is whether prosecutors, independent enough to act, will follow the path the judge has laid out. What happens next will test more than individual accountability. It will test whether the rule of law functions when the individuals involved occupy the highest offices in the land. And that is a far more consequential question than any single immigration policy dispute. If this breakdown helped you understand the stakes, make sure you stay tuned. The next moves in from the courts, from prosecutors, and from the administration could define the balance of power in Washington for years to come.